Hi, I'm Aslam Mullah and I am a registered attorney, and in today's video we're going to be talking about what is the difference between the CCMA and the Labour Court. In particular, what are the important things that you need to know about if you're deciding to take a labour matter. Where do you go? Do you go to the CCMA or do you go to the Labour Court? Let's look at some basic differences. First, let's start off with the CCMA. The CCMA generally is the quickest place to resolve your labor dispute. You can get a date at the CCMA within 8 to 12 weeks. It's very quick. Secondly, the CCMA is generally a very informal process. You have a commissioner who is assigned from the CCMA who will be working on your case and who will be making a decision depending on whether it's conciliation or arbitration. And we've done extensive videos explaining the difference between the two and also how to prepare for a CCMA case. These videos will now be shown. Generally though, CCMA is very quick and very informal. By contrast, the Labour Court is a much more longer process. To get a date in the Labour Court, you're looking at more than a year, firstly. Generally, because of the court rolls that are now being backlogged with a lot of cases. And secondly, the Labour Court is a much more legally driven process. In other words, there are a lot of legal documents that need to be filed. There's a legal process, etc., etc. So the basic difference between the two already is CCMA, quick, informal, Labour Court, much more longer and a formal process. Now let's look at what type of cases can be heard at the CCMA and the Labour Court. So already you might make your decision based on those two factors. But in terms of the kind of cases, the CCMA definitely hears cases regarding unfair dismissals, unfair retrenchments, unfair labor practices, etc. It has the power to hear those cases. The Labour Court can also hear those cases, but it generally deals with more complex legal disputes. For example, large-scale retrenchments or interdicts or reviews of arbitration awards, etc. That's more the line of Labour Court matters. Essentially then, in terms of matters, the CCMA hears unfair dismissals, unfair labor practices, retrenchments, incapacity. It has the power. Same goes for the Labour Court, but generally more complex legal disputes. The third important criterion is the amount of compensation. The amount of compensation that you can get at the CCMA is the maximum is 12 months of your salary versus the Labour Court, which is 24 months of your salary. So, yes, it is double the amount of compensation. However, is it worth waiting that longer period of time? Plus, you're not guaranteed to get 24 months of your salary if you go to the Labour Court. In summary, regardless of that issue of compensation, 12 months versus 24 months, my suggestion is generally go to the CCMA. That's the best approach for your unfair dismissals. It's the best approach for your constructive dismissal, your retrenchment, etc. The reason why I recommend it, it's a quick, informal process and can have your dispute resolved much more cost effective than going to the Labour Court. Of course, if you need help in your situation, whether to prepare your dispute to take it further or whether to go to the CCMA or the Labour Court, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best and I'll speak to you soon.